McCulloch versus Maryland. The facts of this case start in 1816. Congress had chartered the Second Bank of the United States. In 1818, the state of Maryland had passed the legislation to impose taxes on the bank, where a James W. McCulloch, the cashier of the Baltimore branch of the bank, had refused to pay the tax, and the state appeals court held that the second bank was unconstitutional because the Constitution did not provide a taxable commitment for the federal government to charter a bank. And the questions in this case are: does Congress have the authority to establish a bank? And does Maryland's law find itself unconstitutional when interfering in congressional powers? In a unanimous decision for McCulloch, the court had held that Congress had the power to incorporate the bank and that Maryland could not tax instruments of the national government employed in the execution of constitutional powers. Marshall's majority opinion was that pursuant to the necessary and proper clause of Article 1, Section 8, Chief Justice Marshall noted that Congress possessed powers not explicitly outlined in the U.S. Constitution. Marshall had redefined necessary to mean appropriate and legitimate, covering all methods for furthering objectives covered by enumerated powers. Marshall had also held that while the states retain the power of taxation, the Constitution and the laws made in pursuance thereof are supreme and cannot be controlled by the states. No other dissenting or concurring opinion was found. Gideons versus Ogden. A New York state law gave Robert R. Livingston and Robert Fulton a 20-year monopoly over navigation on waters within state jurisdiction. Ogden and other competitors tried to forestall the monopoly, but Livingston and Fulton largely succeeded in selling franchise or buying competitors' boats. Thomas Gideons, a steamboat owner who did business between New York and New Jersey under a federal coastal license, formed a partnership with Ogden, which fell apart 3 years later when Gideons operated another steamboat on a New York route belonging to Ogden, whereas Ogden had filed a lawsuit against Gideons in the New York State Court of Law and had received a permanent injunction. The New York State Court rejected Gideons' argument, asserting that U.S. Congress controlled interstate commerce. The question is, does the Commerce Clause give Congress authority over interstate navigations? The conclusion is, in a unanimous decision for Gideon's, under the Constitutional Supremacy Clause, the New York monopoly was void because it conflicted with federal law. And by majority opinion of John Marshall, Justice Marshall concluded that regulation of navigation by steamboat operators and others for purposes of conducting interstate commerce was a power reserved and exercised by the Congress under the Commerce Clause. As interstate navigation fell under interstate commerce, New York could not interfere with it, and the law was therefore considered invalid. In a concurring opinion to this, Justice William Johnson had argued that the national government had exclusive power over the interstate commerce and negated state laws interfering with the exercise of said power. However, Justice Thompson did not participate in this discussion nor the decision of this case. Plessy versus Ferguson. The facts of this case are, in Louisiana, enacted a separate car act which required separate railway cars for Caucasians and African Americans. In 1892, Homer Plessy, who was 7/8 Caucasian, agreed to participate in a test to challenge this act. He was solicited by the Comité des Citoyens, otherwise known as Committee of Citizens, a group of New Orleans residents who sought to repeal the act. They had asked Plessy, who was a technically African American under Louisiana law, to sit in a Caucasians only car of a Louisiana train. The railway cooperated because it thought the act imposed an unnecessary cost via purchase of additional railroad cars. When Plessy was told to vacate one of these cars, he refused and was arrested. At trial, Plessy's lawyer argued that the Separate Car Act violated the 13th and 14th Amendments. Does the Separate Car Act violate the 14th Amendment? In a 7-1 decision for Ferguson, equal but separate accommodations for blacks and whites imposed by Louisiana do not violate Equal Protection Clause of the 14th Amendment. In majority opinion of Henry B. Brown, imposed racial segregation, Justice Brown conceded that the 14th Amendment intended to establish absolute equality for the races before the law, but held that the separation treatment did not apply to African Americans. In short, the segregation itself did not constitute unlawful discrimination. And in a dissenting opinion, Justice Marshall argued that the Constitution was colorblind and that the U.S. had no class system. Accordingly, all citizens have equal right to civil rights.